to the third principles. Necessity of interim injunction, dishonest adoption, and delay. What is why there is a necessity for interim injunction and IP suit? I think I have already explained you about this particular concept in the previous session itself. Because in an IP suit, unlike any other civil suit, we file a suit. Along with the suit, we also file an application under Order 39, Rule 1 and 2 for an interim injunction that is always there in any suit. IP suits are always the similar one, but IP suits are not exemption to that. But the number of days involved and the duration involved to get an interim injunction is very crucial here. Because in a normal suit, you file a suit, you file an application for interim injunction, and sometimes most of the courts, especially district courts, even in various other high courts, except Delhi High Court or Madras High Court or Calcutta, Bombay, even the various high courts, they always say that let the defendant file the counter affidavit and let the matter be heard both the sides, then they grant interim injunction. In IP, when the commercial value is more, for example, if I have a trademark of a particular product, especially in this pandemic time, assume that the other day I was explaining about Dettol case. So I'm the manufacturer and seller for Dettol. I manufacture and sell soap, hand wash, or whatever it is. In the recent time, we also sell sanitizer or hand wash. When the commercial value is very huge, it goes in crores or lakhs. The opposite party, when they try to misuse or adopt a similar trademark to confuse the consumers and make the money out of it within a short span of time. So we cannot wait for 1 month or 2 months or 3 months, whatever it may be, for getting the interim injunction. Because by the time they would have already done a great damage to the reputation of the product as well as to the commercial value of the product. So there is a necessity of an interim injunction very immediately. That is why in IP suits, we have 3-4 high courts in India. They do wonderful job. Like even our Madras High Court is one of the remarkable high court in India. The very first day when you file a suit and you file an application for interim injunction, when you establish that there is a prima facie case in favor of the plaintiff without even serving the notice to the defendant, or there is not even necessity that you would have sent a pre-suit note before filing a suit, because there is in other civil suit the court asks for a pre-suit note before filing a suit. The court will say, have you sent any notice to the defendant? Have they replied? So all these questions they will be raising. In the IP suits, it is not even necessary to send a pre-suit note. You straight away file a suit and you can ask for an interim injunction by filing an application under Order 39, Rule 1 and 2. If the court finds there is a prima facie case, the very first day, they will grant ex parte ad interim injunction. That is the beauty of the IP cases. Now, I'll explain why that there is a necessity for interim injunction. And also, what is dishonest adoption? Like in the previous case, why the Parleji case, why the other party has adopted a similar image, which is having the overall similarity of the first product. Also, the concept of delay. In the previous case, the defendant took a defense that why they did not file a suit immediately, why there was a delay. So all these points are covered in this judgment. How it has been covered, we will see. Madras Hygiene Industries Private Limited is a Sudhir Bhatia. This is also again from the Supreme Court, citation 2004-3 SCC 90. The facts of the case is that appellants filed a suit for passing off For infringement of copyright, the defendant admittedly worked with the plaintiff prior to launching its business. This is very important because most of the IP suits are between the rival companies or between the rival, they might be even family members. Here in this case, the defendant was working in the plaintiff company and he quit the company and he starts the business, but he copies the plaintiff's trademark. That is what happens in most of the cases. Now we will see what the court says, how it is being handled. The plaintiff prior and prominent user of the phrase, the trademark is called Lakshman Rekha, as part of the description of crazy lines as shown by the document. Advertisements at least of 1991 produced by the plaintiff, showing prominent use of phrase of Lakshman Rekha. The trademark in dispute is called Lakshman Rekha. The defendant non-denial of plaintiff's assertion in the notice dated 28/2/1992. The defendant is also admitting that Lakshman Rekha was used. The plaintiff assertion of the ownership of copyright in the packaging containing the words Lakshman Rekha. When the court asked for a reason, that is why I told you in the previous cases also. The very moment you have an identical or similar logo or image, the first question the court will ask, why did you choose this particular name? Because you worked with the company, you know the name of the company, you know the brand name of the company, you quit the company, you could have selected any other name. But why did you select a similar name? This is what dishonest adoption. Adoption in the sense, I adopt a particular mark. I wanted to start a business. I adopt a mark called Wipro or Infosys, whatever it is. First adopt, and I use. When there is an adoption, the adoption should be a honest one. If it is not a honest one, if you copy somebody else or if you have some other mark in your mind and just to copy that mark, you create some name that is called a dishonest adoption. The defendant has not chosen to give any explanation why he adopted magic Lakshman Rekha. In this case, he just added the word magic as prefix to Lakshman Rekha. Plaintiff's mark is Lakshman Rekha and the defendant mark is magic Lakshman Rekha. That's it. The defendant says that he's been also using from 1992. But in the trademark registry, he's saying he's using from 1996. So he is conflicting his own statements. The matter comes to High Court directly because as like Madras High Court, this High Court has a direct original jurisdiction. The single judge granted an interim injunction preventing the respondents, their agents, servants, distributors, stockists, or any other persons acting on their behalf from manufacturing, marketing, distributing, selling insecticides, pesticides, Lakshman Rekha. So the High Court is giving, the single judge is giving the interim injunction. Then they go for a division bench, appeal, OSA. The division bench, in spite of noting the factors which have been set out by the learned single judge, has vacated the interim injunction merely on the ground that there was a delay. This is what the important factor here. So the marks are very similar, Lakshman Rekha and magic Lakshman Rekha. Though that the defendant was working with the plaintiff and he quit the company, he is having a very good knowledge about the plaintiff trademark. The only reason is that there is a delay in filing the suit because he is aware that the defendant is using. Only on this factor, the interim injunction was vacated. Because it has held that such delay and latches disentitled grant of injunction. The respondents were merely directed to file regular accounts of their sales in the court. then the plaintiff goes to Supreme Court. The Supreme Court says the law on the subject is well settled. So this paragraph is very important because I myself have argued in several cases this particular paragraph. It says that the law on the subject is well settled. In cases of infringement of either a trademark or of copyright, normally an injunction must follow. You can note down the word. The Supreme Court used the word must follow, not may or can. It says must. Because IP suits are of such nature that if there is no such interim injunction, the very purpose of interim injunction will be defeated. That is why it says, in cases of infringement of either trademark or copyright, normally an injunction must follow. Mere delay in bringing action is not sufficient to defeat the grant of injunction in such cases. The grant of injunction also becomes necessary if it prima facie appears that the adoption of the mark was itself dishonest. This is what is very important. There are two things. In fact, there are three things in this particular paragraph. Very, very crucial factor in any case of IP cases. One is that if there is an infringement of trademark or copyright, an injunction must follow, pending the disposal of the main suit. Number two, court says that mere delay in bringing the action is not sufficient to defeat the interim injunction. Number three, if the court finds that the defendant has adopted the mark with a dishonest intention, that itself is sufficient to give or grant an interim injunction. So these are the three important points in this particular. This is the whole case, in fact. The court was asking the explanation for the from the defendant that it has recorded no explanation could be given as to why that the carton had to be changed to look almost identical to that of the appellant at a subsequent stage. This is what is very important. In the initial stage, you can see it is an admitted position that the respondents used to work with appellants. So he admitted that, yes, I was working with the plaintiff. The advertisement which had been issued by the appellants in the 1991 show that at least from that year they were using the mark Lakshman Rekha. So the plaintiff has been using, they are producing some advertisements in the court, at least from 1991 they are using the mark Lakshman Rekha. Not only that, but the appellant have had copyright in the mark Crazy Lines and Lakshman Rekha with effect from 1991. The copyright have been renewed on 1999. A glance at the cotton box used by both the parties show that in 1992, when the respondent first started, the defendant guy, after quitting the company, he started his company. When he started in 1992, he used the mark Lakshman Rekha in cottons containing colors red, white, and blue. So these are the three colors he initially used, but after that he changed the color. That is why he changed the color so that it looks similar to the plaintiff product. Not only that, you can see, not only that he copied the mark Lakshman Rekha, Magic Lakshman Rekha, he also copied the cotton color and the getup. That is why the court says that this prima facie indicates the dishonest intention to pass off his goods of the appellants. So he had a clear intention, dishonest intention. He adopted the similar mark. Initially, he had a different packaging design. Subsequently, he changed so that the subsequent design looked similar to the plaintiff product. We all have to think why they are changing the design and why they are changing the logo. Because that is where the goodwill plays an important role. When a consumer buys a product on a large scale, the product has already, the product has already many consumers and people have very good reputation about the product. That is why many people started buying the product. So by using that goodwill, It's not very easy to create the goodwill because they used, I mean, they got it extensive use, spend a lot of money for advertisements, and they spend a lot of money for marketing or distribution. End of the day, they are getting this goodwill. So with that goodwill, the defendant who is a new party who has just entered the market, they'll try to exploit all this goodwill created by over a period of time and by spending huge money. So there, the court says that no, you can't do so. That is what the dishonest